Hello, ladies and gentlemen, and welcome to Introduction to Law. This is our first educational video, and we are going to talk about the basics of law in this session. So let's start. The first question that you as students of law and international relations have to ask yourself is what law is. So the question is, what is law? Law is about do's and don'ts, is and out, right and wrong. Now, most people would agree that the law governs human behavior by rules. It forbids certain ways of behaving. For instance, stealing, killing, or exceeding speed limits, and prescribes others. For example, paying taxes or driving on the right lane. Legal rules are also called norms. The law does not stop at setting up rules. It also secures compliance with them by threatening persons who disregard a rule with some disadvantage, like being imprisoned or having to pay money. This consequence is called a sanction. The task of the state is to put the sanction into effect. For instance, to put the offender into prison or to take the money from him. We say the sanction is enforced by the state. As for is and out, the legal rules do not describe facts. They do not tell us anything about reality. Instead, they specify facts and describe what should happen if they are fulfilled. They say what ought to happen in certain situations and what consequences should follow if this does not happen. For example, if a newspaper reports that Madame Bouvier was sentenced to jail for life for killing her husband, it describes facts. The relevant legal provision says, whoever kills another person will be sentenced to jail for life or will be imprisoned between 10 and 20 years. This has several effects. First, it prohibits murder. Second, specifying that a murder has been committed, it describes what should happen to the perpetrator. Now, let's deal with rights and wrongs. Many people think that the law not only prescribes or forbids certain acts, but also indicates what is right and what is wrong. But how do we know whether the rules set up by the law are fundamentally right? How can we be sure that they are just? We have two different doctrines in this respect. The doctrine of natural law tries to answer this question by referring to meta-legal authority. According to its adherents, law is correct if it conforms to the human nature, to divine revelation, or to reason. The positivist doctrine accepts that we have no means of deriving law from a higher authority. It points out that the law is made up of social norms which are generally accepted and adhered to, and are formally enacted or are regularly enforced. Now, here's the question. What are the aims of law? What do they provide? A lawyer would answer, Law books usually describe the law as a system of rules enforceable by public authority, requiring the members of a community to meet certain standards of conduct. They go on to state that the law makes sure that the society remains stable and its members are able to pursue their interests, and that disputes are settled efficiently. To this purpose, the law should conform to public morality, without, however, turning all moral norms into legal rules. Now let's talk about the historical development of private law. And let's start from Roman law as the basis of most legal systems in today's Europe. After the enactment of the 12 tablets in 450 BC, a code that concentrated on the most important problems that had arisen under the customary law, a body of specialists called jurists emerged who studied the law systematically and practiced it by giving legal advice and by teaching. Case-by-case approach, they developed the fundamental legal concepts. For example, obligation, property, pledge, contract, possession, etc., and the methods of formal and substantial reasoning. Formal reasoning works with the meaning of the words, parties' intent, legislative purpose, analogy, and logical conclusions. Substantial reasoning involves arguments based on values such as good faith, fairness, equity, public policy, practicability. It is important to notice that the jurists were no judges and their work was not concerned with the facts of the case. To ascertain the facts and to decide the cases was left to the judges. The jurists only gave legal opinions on which the judgment could be based. Corpus Juris Civilis. By the end of the classical period of the Roman law in the 3rd century AD, the hundreds of law books and commentaries produced by the jurists had become totally unmanageable. Around 530 AD, the East Roman Emperor Justinian compiled the material into 4 books: the Digest, the Institutes, the Constitutions, and the Novels, which were later labeled as the Corpus Juris Civilis, a monumental work of about 1 million words. Now, let's talk about private law in Western Europe. After the decline of the Roman Empire, the Roman law remained formally in force, but was in practice superseded by tribal laws and local customary laws. In the 12th century, Irnerius, a professor of grammar at the University of Bologna, started to work on the Corpus Scholarly. He founded a school that became known as the Glaciators. They started by analyzing the meanings of the words and went on to uncover the underlying general principles and to examine the purpose of the rules. Until the 15th century, Roman law spread to the universities all over Europe. Another school, called the Commentators, concentrated on adapting the findings of the glaciers to the practical problems of everyday life. They developed the commercial law and the international private law. During the same time, canon law arose, the law of the Catholic Church, which applied to clergymen and to laymen as far as marriages and wills were concerned. The graduates from the universities became judges or secretaries and chancellors to the rulers. Applying the Roman law they had studied, they gradually overcame the customary local laws. This process is known as the reception of the Roman law. The Roman law, as developed by the medieval scholars, became jus commune, the common law all over Europe. Now, law in modern times. In modern times, the idea of the sovereign national state emerged. The rulers aimed at establishing national laws within their territories. It was again the scholars that worked out national codes on the basis of jus commune and the rationalist natural law doctrine that had been developed since the end of Middle Ages. The ideal of a code was to present the law in such a way that any legal question arising out of any situation could be solved by referring to the text without giving the judge too much discretion. To achieve this purpose, the legislators used abstract concepts and principles which describe the characteristic features of the legally relevant situations in everyday life. For example, exchange of property, damage to physical integrity or to property, marriage, last will, and many others. The first great codification was Prussian Code of 1794, followed by the Code of Napoleon of 1804, and the Austrian Civil Code of 1812. These codes reflect the spirit of enlightenment and rationalism, of equality of the citizens, freedom of private legal relationship from state control, and freedom of economic activity. After almost a century of further intensive academic activity, the German Civil Code of 1900 and the Swiss Civil Code of 1907 followed. Their philosophical and ideological foundations are similar to those of the elder codes, again stressing freedom and equality of the citizens, as well as private autonomy. Both these codes carried abstraction so far that they had the effect, unintended in the case of the German Code, to give the courts large leeway to adapt the law to the difficult social and economic conditions of the early 20th century, thereby creating an extensive body of case law. Civil procedure. Until the end of the 19th century, civil procedure on the continent was strongly influenced by the canon inquisitorial procedure. It was the task of the judge both to ascertain the facts by conducting appropriate inquiries and to find the law. The proceedings were largely conducted in writing. The modern civil procedure is based on the principles of orality and adversariety. It is the task of the litigants to assert the relevant facts and to prove them. The judge then decides what facts he considered as established and makes the legal ruling. Private law in England. After the conquest in 1066, the Norman kings established a strong central government. They did not abolish the local customary laws, but set up a king's court which they encouraged to compete with the local courts. The King's Court soon developed superior procedural rules. They gave the parties freedom to present and conduct their case in the way they thought would fit without conducting inquiries of their own, adversarial procedure. They introduced juries to establish the facts, jury trial, restraining themselves to resolve the question of law. The royal judges accomplished a task similar to the Roman jurists, not starting from abstract principles, but by a case-by-case approach. They created the common law. From the early 13th century onwards, their decisions were reported in writing, and a huge body of case law evolved. The judges considered themselves bound by their own previous decisions, precedents. By the 15th century, the common law was fully developed, but there were two inconveniences. The only remedy was money, and the court procedure had become extremely technical. To overcome these problems, the king instructed his chancellor, usually a clergyman trained in Roman and canon law, to hear complaints and to grant relief. The chancellors developed equity, a body of rules that corrected and supplemented the common law, and they created the equitable remedies designed to provide what was needed in the particular circumstances, especially specific performance. Unlike on the continent, the universities had almost no influence on the development of law. Until the end of the 19th century, the lawyers were trained and organized in professional guilds, inns of courts. And until very recently, the judges were appointed exclusively from the members of the inns, or barristers. The 20th century. The common law and the civil law systems converge. In the civil law, the case law has gained in importance, and in common law, statutes become more numerous. Recently, the British government introduced significant changes to civil procedure in order to reduce the adversarial character and to introduce inquisitorial elements. International and supranational organizations have been created that increasingly determine the laws of the national states and even take over more and more legislative powers from them. Human rights have been enacted on an international level: Universal Declaration of Human Rights, European Convention on Human Rights, African Convention on Human Rights. They have increasing influence on the interpretation and the development of private law. Major legal systems today. Civil law, German tradition, includes Austria, Germany, Switzerland, Liechtenstein, Greece, Turkey, Japan, South Korea, and Thailand. Civil law, Roman tradition, includes France, Belgium, Luxembourg, Spain, Italy, Portugal, Egypt, former French colonies in Africa, Ethiopia, Haiti, Bolivia, Dominican Republic, Chile, Peru, Louisiana, Quebec. Common law countries include Great Britain, former English colonies, and the USA. We also have Scandinavian law, socialist laws, and religion-based laws, including Islamic law and Hindu law. Working with rules. A norm specifies certain facts and describes what should happen if they are realized. We can identify an if structure. If certain factual elements are fulfilled, a certain legal consequence ensues. Thus, a norm consists of two parts, the elements and the legal consequence or sanction. Example, Article 169 of European Commission Treaty. If the Commission considers that a member state has failed to fulfill an obligation under this treaty, it shall deliver a reasoned opinion on the matter after giving the state concerned the opportunity to submit its observations. If the state concerned does not comply with the opinion within the period laid down by the Commission, the latter may bring the matter before the Court of Justice. The elements may be real facts, psychological facts, but also a legal concept, a legal rule. The norm describes certain categories of situations, certain sets of facts. Therefore, the elements are general in scope and are described in abstract terms. The consequence may be, in private law, an obligation to do or not to do something, an amendment to a legal setup. In criminal law, a sentence. In public law, an order or a permission to do or not to do something. Of course, not every sanction in the law codes is couched in an if-then structure. Sometimes the order is reversed or the wording is different. It is also possible that the norm has to be drawn from several different parts of a section or different sections of a statute. Subsumption. To apply the law means to bring the facts of the case at hand under a particular rule of law. We convert the general and abstract norm into an individual and specific one. This involves the following steps. 1. First, we have to ascertain all seemingly relevant facts of our case. 2. Then, we look for the appropriate rule. 3. Next, we identify all its elements. 4. Then, we have to check whether the facts before us fit the elements of the rule. For the consequence to ensure the facts must fit every single element of the rule. Interpretation. Interpretation is a key part of legal practice. To see whether facts fit with the elements, we have to interpret the words which describe the elements. We have to find the meaning of legal wording. This process of interpretation follows itself certain rules. Literal interpretation, which means what does the term ordinarily mean? Systematic interpretation, which refers to what is the context with other legal provisions. Historical interpretation. How did the rule develop? Teleological interpretation. What is the purpose of the rule? What happens if apparently we cannot find a rule that applies to the case in question? We may either conclude that the legislator did not intend to make a rule in point, so that the law has a gap on this point, or we may construct a new rule from given rules by analogy or by generalization. Legal interpretation is formal because the texts a lawyer interprets are in writing and have authority as they can be statutes, contracts, treaties, or wills. The interpretation chosen will make a difference to someone's rights and duties. There is another way in which the interpretation of a legal text is formal. When it is disputed, there is such a thing as an official interpretation of the text. Judges provide this when they try cases or hear appeals. Ministers and servants also issue official interpretations of statutes, though their interpretations have in the end given way to those of judges if there is a difference of opinion between the two. Another way in which the interpretation of legal texts is unlike interpreting a request from a friend is that the evidence on which the interpreter of legal texts has to come to a decision is limited. Question: if I am not sure what my friend meant by his request, my best move is to ask him. But in general, problems of interpreting legal texts cannot be solved by going back to the authors. Could you explain why? Working with cases. When reading a common law case in the law reports, 4 elements should be identified: the facts, the circumstances that gave rise to the lawsuit, the legal issue, which are the legal problems the judge must resolve, the court's decision, which is the judge's answer to the problem, and the court's reasoning, which is the basis and rationale for the decision. This ought to be distinguished from obiter dicta, which are those arguments in the reasoning that do not directly support the decision. As already said, English courts follow their previous decisions, doctrine of precedent. The part of the case that is considered to possess authority is the ratio decidendi, the rule upon which the decision is founded. The ratio decidendi of a case can be defined as the material facts of the case plus the decision thereon. It is found by a process of abstraction. Wilkinson versus Downton, 1897. Let's work on this case as an example. These are the facts. The defendant, by way of what was meant to be a joke, told the plaintiff that the latter's husband had been smashed up in an accident. The plaintiff, who had previously been of normal health, suffered a shock and serious illness. Held: the defendant was liable because he had willfully done an act calculated to cause physical harm to the plaintiff and had in fact caused such harm. Shock and serious illness means physical harm. The joke or the lie are an calculated act to cause harm. Now let's work on another case. Donahue versus Stevenson, 1932. Here are the facts. The plaintiff had been invited to a drink in a country inn during a walk in the hills of Scotland. She ordered a bottle of ginger ale. The drink came in an opaque and sealed bottle. Mrs. Donahue opened the bottle and took a sip. When she poured out the rest, parts of a decomposed snail came out of the bottle. The plaintiff suffered shock and gastroenteritis. Held: a manufacturer of products owes a duty to the consumer to take reasonable care in the course of the production and is liable for damages if the consumer suffers physical harm in consuming the product. Ginger ale producer is the manufacturer of the good. Shock and gastroenteritis is the physical harm. This means economic loss. Generality. Why study the law? The law addresses itself to all members of a community or all persons living within the state. A state has power to regulate any set of facts with the exception of an exempt sphere guaranteed by the human rights. The legislator is free to make rules for specific groups of the community, which is entrepreneurs, and for specific fields of activity. Every member of the society is supposed to know the law. Not to know the law is no excuse. In business, like in ordinary life, managers and their companies may become liable to damages or penalties if they do not conform with the legal requirements of their business. Knowing the law improves one's understanding of the courses of action available. Thank you very much, ladies and gentlemen. This is it for today. I will continue posting these videos on our Moodle platform.